Today we're looking at Wrinkelmen versus Parma City School District, beginning with the background. The background of this family is that they had less than $50,000 per year. They had 7 people in their family, including the mother, Sandy, and father, Jeff Wrinkelmen, and 5 children, including their youngest son, Jacob. This family lived in Parma City, Ohio. When Jacob was 4 years old, he was diagnosed with autism spectrum disorder. During the time of the case, he was 6 years old. He is the youngest of 5 brothers and sisters and qualified for an individual education program, or IEP. The initial court case took place because Jacob's parents, Sandy and Jeff, claimed that their son Jacob was denied a free and appropriate public education, otherwise known as FAPE, as required by the Individuals with Disabilities Education Act, or IDEA, by the Parma City School District. Jacob was placed into a public elementary school in the Parma City School District, but his parents did not feel that this met his needs, and so they moved him to the Monarch Center for Autism in Cleveland, Ohio, at their own expense. Part of the initial court case was to receive reimbursement for this expense. However, as we'll see in the verdict and appeal, that the judge ruled in favor of the school district and did not reimburse the family for the expense, but that Jeff and Sandy decided to appeal this decision. The appeal was denied because they did not have a lawyer representing Jacob. The judge stated that IDEA protects the rights of the child, not the parent. The timeline of this overall case began in 2003 when Jacob was placed into Parma Public Schools. Jacob's family moved him to the Monarch Center at their own expense. The initial court case was about reimbursement and FAPE for Jacob. However, the court case needed to be appealed, and that appeal took place in 2005. When the 6th District Court denied the appeal, the family took the case to the Supreme Court in February of 2007, and the final decision was made in May of 2007. The Supreme Court case looked at the law issue of whether or not a non-lawyer parent of a child with disabilities could argue in federal court on their or the child's behalf under IDEA.
All rise for the Honorable Judge. You may be seated. This is the case of Wrinkelmen versus Parma City. Here we have Jeff and Sandy Wrinkelmen and their son Jacob, and a representative from the Department of Education. Wrinkelmen, state your case.
All right, Jeff. So, we believe as Jacob's parents that we should be able to represent our son Jacob. In the 6th court, we weren't even able to represent him because we don't have a lawyer. But in school, we can represent him for IEPs. I just don't understand that.
Objection.
Objection ruled.
The Individual with Disabilities Act, also known as IDEA, protects the child, not the parent. Jacob should have a lawyer, as if any case would, if he wants to discuss a legal issue.
He's 6 years old.
That is not the point.
What?
We're discussing IDEA.
Uh-huh.
We have deliberated and are ready to rule. Our verdict is parents enjoy the rights under IDEA and they are entitled to prosecute IDEA claims on their own behalf.
Thank you. Yay!
As you saw in that video, the U.S. Supreme Court reversed the 6th Circuit Court decision in favor of the parents' choice to not use a lawyer. The reason given was because parents enjoy the rights under IDEA and they are entitled to prosecute IDEA claims on their own behalf. For special education in the future, this means that parents of children with disabilities can represent their child in federal court with or without a lawyer under IDEA. We'd like to thank Kat Brighton for playing the Supreme Court Justice, Amber Brial for playing the Department of Education representative, Justina Moreno for playing Sandy Wrinkelmen, Justina's Backpack for playing Jeff Wrinkelmen, and Brandy Hyder for playing Jacob Wrinkelmen and narrating. Our film crew was made up of Justina's laptop webcam, and for case information, please visit this website.